Kick off this hour with an update on the legal matter that has dogged South Africa for more than 15 years and cost taxpayers millions. Former President Jacob Zuma is in court seeking to have 16 charges, including racketeering, money laundering and fraud, put to bed forever. The charges relate to hundreds of payments he allegedly received from his former financial advisor, Schabir Shaik, and an alleged 500,000 rand a year the pair wanted from French arms company Thales to protect it from investigations into the multi-billion rand arms deal done in the 1990s. Now, in 2005, Shaik was found guilty of corruption. The court found that he had solicited bribes from then Thomson CSF, now Thales, for Zuma's political influence. Zuma himself was only charged with corruption in 2008. But a year later, when presented with the so-called spy tapes, prosecution's boss Mokotedi Mpshe dropped those charges. In 2016, we fast forward, the North Gauteng High Court overturned his decision, and last year former NDPP Shaun Abrahams reinstated the charges. So that's where we are now. What are Zuma's chances of making this matter finally go away? To discuss, we're joined by litigation expert advocate Mokotedi Mpshe from our studios in Durban. Thank you for being with us, advocate. So I've run through the criminal matter that's taken more than a decade, heading towards two. The current matter that's being heard is civil. Explain the difference for us.
Thank you for having me. Well, we have taken us through what has happened throughout the years with the criminal matter. There is a distinction between the criminal matter and the application we have been hearing from Monday. What you have is a criminal trial that has been instituted, withdrawn, reinstituted, and where now we're sitting at a place where the former president as well as Thales are seeking that the matter be permanently stayed. The distinction is that the application is a civil application, which, even though it derives its facts from the criminal matter, it is all the evidence is in affidavits, and all parties are given an opportunity to make their representations. The states will be given an opportunity to make their representations, as they have started already. And finally, the applicants in the matter will have an opportunity to reply. So the distinction between the two is that in an application, there is no evidence that is led by testimony. It is only in affidavits. And the application is filed with what the applicants seek as an order from the courts, giving all the evidence they are going to use in their representations in the form of affidavits. And the states then has an opportunity as respondents in this matter to answer that, and a reply from the applicants. Then the matter is closed. So after that, they submit their heads of argument to the judges, who are going to have a snapshot of what their submissions will be. All the evidence is laid on paper, and the submissions made are legal to allow the courts to make a determination in law. We are not going to the merits of the case. We are not going into the facts of the case, only concerned with the procedure and whether they are entitled to the order that they seek before court. So
it's not about the merits of the case. Is it fair enough to say this is all about time? If the court grants this request to Zuma and Thales to stay the prosecution, basically to put it to bed, will it be because justice delayed then becomes justice denied?
Well, with an application to permanently stay a prosecution, the court has to consider three things. The first is the nature of the prejudice to the accused persons. The second is the nature of the matter. And the final one is whether it was a systematic delay. So when the court is making all those considerations, they don't look at them in isolation. So the submissions, as we heard today from Thales representatives, are that there's an unfairness, which means that the requirements of of prejudice is satisfied. And then they went on to discuss the irregularities and what caused the delays. And that is their way of explaining to the courts or representing to the courts that they are indeed entitled to the relief that they seek. So just to sum it up, if they can prove that they are prejudiced because of the delay, that they are not the cause of the delay, and that it is the state that is the cause of the delay through its actions, and finally, that it was not a systematic delay, then they are entitled to the relief that they seek. So their submissions today, as we heard, is that the unlawful actions which of the former head of NPA were the cause of the delay. Secondly, that the reinstatement of the charges was irrational, was procedurally irrational, and that they should not be looked at as an add-on to Zuma. So essentially, that's what their argument boils down to.
Okay,
and then they went on to the irregularities.
Let's stay with Thales then. What do you make of that argument that Thales is saying it was only charged because Zuma was charged? It wouldn't have been focused on by the courts on its own merit, so it's an add-on. Is that a strong argument?
Well, as you would have seen today in court, there was a back and forth between His Lordship and ladies as well as counsel for Thales on this issue of being an add-on. Legally, the head of the National Director of Public Prosecutions is empowered to decide whether to institute or to stop or to reinstate charges. And the argument there, I think, essentially was that when the charges were withdrawn, when the charges were initially withdrawn, it was an irrational decision. And that when the charges were reinstated, they were not given an opportunity to make proper representations, and that they should have been treated as their own entity. Then the question from the bench was that, is counsel submitting that the Thales should be treated differently because they are a corporate entity? And if counsel accepts that they benefited from, and benefits is used loosely here, if they benefited from the withdrawal initially, then does it not follow cause that if the matter is reinstated, they are also the charges against them are also reinstated? So it was a back and forth, and as you remember, the matter was just left there because there was no agreement between the bench and counsel for.
Well, have you heard
Thales.
this argument before, that they should be treated on their own merits? I mean, surely the state could come back and say it was logical and it's efficient to charge the two together.
Well, the state did say that in its submissions today, albeit in bullet points, that the reason why the matters were joined and they were heard together is because they flow from similar facts. And it was in the interest of justice for both matters to be heard together. So if they were heard together initially and they were withdrawn at the same time, it makes sense for them to be reinstated at the same time. The argument I think that it was trying to make is that they were supposed to be given an opportunity as an affected party to make representations. And the question from the bench again was, is counsel for Thales insinuating that there is a legitimate expectation from an accused person that they are given an opportunity to make representations? And you remember there was an example that are we now saying that anyone who is accused should be given an opportunity or asked what they have to say about it? There again, there was no consensus and there was no agreement between the bench and counsel. I cannot give an opinion on whether it's a valid argument or not. However, it is within the powers and the purview of the head of the National Prosecuting Authority to make decisions whether to join matters, to institute proceedings, to withdraw, or to reinstate.
So, talking about people being charged together. Talking about people being charged together, can we go back in time? Remind us why Jacob Zuma was not charged with Schabir Shaik. Maybe if that trial had happened way back when, we would have avoided all this proceedings for years.
Well, there have been talks of that, of why Jacob Zuma was not charged at the time with Schabir Shaik. I think that it just goes legally, it just all goes back to the powers of the head of the National Prosecuting Authority. When the head of the National Prosecuting Authority makes a decision to institute proceedings, they have to follow the policy. And we heard talks of the policy which is binding on the National Prosecuting Authority. They have to look at whether there are prospects of success, whether they have enough evidence, whether they have the resources to prosecute. So if that was taken into consideration and they made a decision not to charge Jacob Zuma at the same time as Schabir Shaik, it was within their powers. So I think the argument there would be that the decision rested with the National Prosecuting Authority's head, and we cannot speculate on how they arrived at the decision. Yeah. But they are within their powers to join matters or to try them separately.
So we could say maybe just history would have played out differently. It's always been odd that Jacob Zuma has said he wants his day in court, but he's tried to stop this trial going ahead several times. That Stalingrad strategy was even stated explicitly by his legal team at one stage. So will it come down to here who has really delayed the matter for 15 years, whether it's been him or the state itself?
When we're looking at the issue of time, we have to consider the matter from the investigation, from its inception, so from investigation to charge to finally the matter coming to trial. You remember that the withdrawal, the time between the withdrawal and the reinstatement was a period of about 9 years, and then there was the issue with the legal fees for the president, where the submission from counsel at the time was that until he's able to make to be certain about his legal fees, then the matter cannot continue and is entitled to postponement. So the court in that instant, I would think, would look at time on both sides, the contribution of the state in the delay, and you take into consideration the conduct of the NPA from the inception of the matter to the time that the charges were reinstated. The court will definitely also have to consider that there have been several requests for postponements on the part of the defense. So it will have to weigh on both sides and make a determination based on that, but it will definitely consider both.
Advocate, are you willing to say, what do you think Zuma's chances are here?
I cannot speculate what Zuma's chances are, but if, as I explained before, that this is an application, we saw Skakane SC make his representations, and we saw today a counsel for CATS SC and junior counsel in the matter are making their submissions, and we can see where the state is going with its submissions. I think we will be able to tell when we get to a point where the applicants are replying to submissions from the state. Then maybe we can look at what are the possibilities, but at this point it's very difficult to say because we have not heard the representations of the state.
Sure. If you look back over time, do you think South Africans have seen justice in action here, or the wheels of justice, or have we seen complete dysfunction? I mean, you have someone dropping a case over political interference, then years later the courts say, well, that actually wasn't an issue. He still needs to be tried. It has felt like sometimes South Africa has been playing in the dark a little bit.
Well, with regard to that, I think justice is a broad term, but if we're looking at it from a legal perspective, what we have, unfortunately, today is a state where the court has to look at, as you said, interests of justice as well as balancing the rights of the accused. Unfortunately, our constitution protects the rights of unfortunately, protects the rights of accused, and that's in terms of Section 35. So they have a right to a speedy and fair trial. So if the courts can, if the court today is faced with having to weigh between the interests of justice as well as the rights of the accused, and that is what I would think is a definition of what justice is. In terms of public opinion, I cannot comment on that. However, if put plainly, you have a national director of public prosecutions making an irrational decision, which causes the delay, which is now a reason for the order that is sought for a permanent stay of prosecution. I think South Africans should judge for themselves on whether there has been integrity in carrying out justice.
All right, finally, Advocate, and quickly, if you don't mind, what do you expect from the state that will start arguing against this application on Thursday?
Well, the state made it clear today that they are going to argue. They are going to argue that even though there are all these factors that both counsel for the first applicants and the second applicants, all the submissions that they've made, that they do have a right to prosecute, and that it is in the interest of justice to prosecute. So essentially, they'll be making an argument that all those three factors are present, and that there is no prejudice suffered by the applicants for the supposed delay, and that the nature of the case requires the court to rule that it is in the interest of justice for the trial to continue, and finally that it was merely systematic delay that has led to these delays. I am not sure I cannot speculate what their comments are going to be with regard to the irregularities, as pointed out by Skakane SC, and I am not sure what their reply could possibly be with regard to the two factors, the two main arguments of CATS SC. The first, that the National Prosecuting Authority's head, Sean Abrams, at the time was not empowered to make the decision that he did make. Alternatively, that if he did have the power, he was not aware of it, and therefore it was an irrational procedural decision. And finally, the irregularities. So the state has to reply to all of that. It has been said that it is perhaps the state on trial in this application, but I expect that they will run along the submissions that were made today, that it is in the interest of justice that the accused continue to be tried.
All right, and we'll bring you those proceedings. Follow that closely. 15 years and counting. Thank you for your time, Advocate Mokotedi Mpshe, commenting on the Zuma and Thales trial.